Hi, guys. It's Kathy. I hope you're doing well, and I hope to God you can hear me. I've had nothing but technical issues. I'm going to leave my mic unmuted for this first clip. Kelly sent this to me, and it's the funniest thing I've ever seen. And who just said they were popping in? Rebecca, you just got to stay for 3 minutes. Just stay for 3 minutes. It is so funny. It's worth it. Quit your job, divorce your husband, send your kids to adoption if you have to. This is the website that I got it from. Oh, it's so funny. And then we are going to do that whole Kimberly Joy Hurd trial. It's going to take 13 days. So we're going to start. We already did like part 9 because it was great. So we're going to the beginning and we're going to do the whole thing. And we're going to get more of that judge who is just done with everything. All right, but first, unmuted. I'm not going to mute it. Here we go. Oh man. Oh man. All right, hold on, breathe.
Ray, what happened during the set list?
I turned round. I was dancing and I turned round, and Tommy had come from the back door on the stage with this on.
Can you bring that to me, Michelle?
I didn't bring this, it's there.
Do you know what it is?
I do.
Right, so what is this? What are you giving me?
It's, what do you call it? Mankini, is it? Mankini.
Come on.
Sorry about that. I need a drink. Oh, sorry.
You turned around
Yeah.
and somebody was wearing this green, you described it as a mankini.
Yeah, well, that's what it is, isn't it?
Now, bearing in mind, I need to make sure I'm in my listening pose. Which of these two gentlemen was in the mankini?
My friend there, Tommy.
Tommy was in the mankini.
Excuse me, Julia, I wore it, but I felt embarrassed wearing it because I've never seen one before. But it was accidentally, I put it on by the front. I didn't do it on purpose.
It was an accident. It was an accident. It was an accident.
And now the words which come frighteningly out of my mouth. I think we have a picture. Now, this is somebody wearing this mankini correctly.
It's Fozzie! Oh my god, it's Fozzie. I'm not muting myself, not for this. Nope. Not.
Just to be clear, for the avoidance of doubt, Tommy, that's not you, is it?
No, that's Fozzie.
Accidentally, though, it weren't done on purpose because there was nobody tell me in the room to put it on properly, you know what I mean?
At that time, you hadn't told Ray that this was going to be put on.
So Ray might have been unaware of it.
Well, that's his point, and I think it's not in dispute. You were unaware that Tommy was going to put this on, correct? You were not aware. So you turned around,
didn't know.
That's right, and there's Tommy sporting this. But not only is he wearing it, but as I understand it, Tommy, you didn't put it on properly. Am I right?
No, I put it on back to front by mistake, you know, to nicely done with.
What actually happened? Did you put it on back to front?
It wasn't, no, you know, the wide bit that goes at the bottom.
That way.
They had that piece on his chest.
Accidentally, it weren't done on purpose. I've never seen one before.
Oh my The wide bit. The wide bit was over his chest. wish I was there. Oh, I wish I was there. All right, Tiffany, love, you can go back to sleep now. And I'm so sorry about soda poppin'. I'm so sorry. Good night. It doesn't. It does not come with instructions. You're right. So anybody could make that mistake, I guess. Oh my gosh, Kelly. Kelly found that for us. Kelly, that was amazingly awesome. Thank you so much for that. Good night, baby. Oh, I'm crying. I'm crying. Oh man, now we have to go to court cases. So, Kimberly Joy Hurd, we saw her a couple days ago. I don't know how many days ago, but it was less than 10, I think. And she was pro se. And she's going against a lawyer. You know, he has a lawyer. So today, it looks like it starts off back in 2022. This is the first video she has posted. I'm sorry. I'm sorry, that's just so funny. Anyway, focus. So, right after Christmas in 2022, there's a motion to dissolve a TPO. And this is where the whole thing begins. This is a different judge though, so I'm sure this judge isn't done with it. So this judge is probably going to be professional, right? But here we go. We're going to get started on this. Hope you can hear it. Judge, why are you calling me in the middle of my stream? Knock it off.
Good afternoon, this is Chris.
Hi, Mr. Phillips?
Yes, ma'am.
Hi, Mr. Phillips. This is the family court TPO calling for the hearing on Opapari and Hurd.
Yes, ma'am.
Okay.
The flag behind her, I think it's Nevada, is what we decided the last time we played this. So I think this is Nevada. If you can read these little squiggly lines right here, you would know for sure.
Hey, I was waiting for your client to show up, but I don't have him here. Is he intending on being present today?
I honestly don't know, Judge. I apologize for any noise. I actually got stranded in Seattle before Christmas, and I'm driving back from Seattle because I couldn't get a flight home.
Okay.
So I am not even in Nevada, so I don't know, and I haven't been able to talk to my client.
Oh.
But I am. If
Nevada.
To go forward, I'm prepared to go forward with or without him.
Yeah, I have to.
I did talk to him.
Yeah.
Yeah, I talked to him last week before Christmas, but just because I'm on the road today, I haven't had good contact with him.
Okay. All right. Well, we're on the. Yeah, I don't really have a choice. This matter was miscalendared and not set within the appropriate time frame when it was filed. I'm not sure what happened within the clerk's office, but Ms. Hurd was entitled to a hearing within 7 days, and it's been far longer than that. In fact, I think it's been almost 3 weeks since she filed this motion. So I really don't have a choice. I do have to proceed today on the request.
And I don't have any objection to that.
All right, we're on the record. T22-229781T, the matter of Opapari versus Hurd. This is the time
Sometimes.
set for the court to consider the motion to dissolve the protective order. We've got the applicant appearing in person. I'm going to try and put this on over the speaker. Counsel, your appearance for the record.
Good afternoon, Your Honor. Chris Phillips, 14600 on behalf of the applicant Mario Opapari.
Okay. All right. We have really bad audio in this courtroom. Were you able to hear what he said, Ms. Hurd? Okay. Ms. Hurd, I've reviewed your motion. Was there anything else? I reviewed your motion. For whatever reason, if you submitted a thumb drive with your exhibits, you had some audio, some video that you indicated that you submitted. The clerk's office did not upload that information into the folder that they were supposed to provide it to me in. So I haven't heard any of that. But I've read your motion. So tell me anything else that you wanted to tell me.
I tried to be really thorough with this.
You were.
Because I've been dealing with this for the last year, and I let a lot of things go, and this time I was just like, I can't do this anymore, so I went line for line, trying to show every lie and everything, because I have really tried to stay focused on my daughter, but I keep getting this side harassing things by the attorneys and by Mario. To reference your flash drive, I didn't submit the flash, I was referring to their flash drive that I sent them, and this is what they're stating. They're stating it's one thing. I submitted into exhibits. I got the link from the court where I submit the exhibits, and then I upload them, and then I got verification that they did receive that. So,
Okay.
As far as submitting the evidence, I think that's how I was told to do it.
Okay.
And basically, what that is just, I'm stating, I did send him that flash drive. It was a discovery for a small claims case, and it was video documenting what I left behind, some of our exchanges at the police department. It was absolutely nothing that Mr. Friedman referred to, so I, of course, have to prove everything I say and do. So I submitted those to show the court what actually those videos were, so there's not even a close. It can't even be speculated that I'm surreptitiously recording them and sending them via certified mail, my recordings. So I just wanted to everything I state, I just try to prove it as much and the best that I can. So that's what they were. And then some of my other assertions, because I did try, like I said, tried to be really thorough this time, because I have not been as thorough, because it is so time consuming, and I represent myself. I'm in Supreme Court right now, and I don't know what I'm doing. And this week, December 7th, I had a fast track statement due. So I was dealt with this, and I'm trying to do something in Supreme Court that I don't have a clue what I'm doing, and I'm just trying to fight for my daughter. So I kind of was, and I feel like this was, in fact, their way of harassing me, and because now they're coming after me in Supreme Court saying it wasn't filed in time, but they don't mention anything about the TPO, that they served that on me on the 2nd, and that I also had this due. So at this point, I've just decided, I'm trying to be as thorough as I possibly can. If there's more questions or anything that you have with me, I'm certainly glad to respond to them. I tried to be as thorough in this. I don't really have any more to say other than we are in Supreme Court, and I am having to deal with their harassment on that level too. So I'm having to redo my fast track statement now. So I'm just trying to do the best I can. I have a criminal case, I have this TPO case, I have a Supreme Court case, I have a case I will be filing in district court because I filed in the wrong jurisdiction with small claims. So it's like, I have all this stuff, and all I'm trying to do, I have a little girl that has Down syndrome that needs her mom, and I haven't been able to see or talk to her in over 90 days.
Yeah.
Okay. Yeah, I mean, I am kind of concerned, I have to say. I'm a little concerned about some of the things, Mr. Phillips, I mean, the questions, on the application, that with respect to prior cases and whether Mr. Opapari has ever been arrested for domestic violence, I am concerned that those were not answered truthfully.
Well, if I can address that, Judge. So,
Yeah, please do.
NRS 179-285 addresses that.
I'm
The
sorry.
charge that 179-285
Yeah.
addresses that issue. That is our statute on criminal record sealings.
I know all about criminal record sealings. It doesn't answer the question as to whether or not he was arrested.
But it says that issue was, because it's been sealed, is deemed legally to have never occurred. So because there's an order from the district court sealing, his civil rights restored, legally able to answer no to this question. So I think that may have been his confusion in filling out the application, because his prior counsel had instructed him, which was long before my office represented him. We didn't represent him 20 years ago when that charge occurred. But because there's a district court order saying that he's not required to disclose that, given that it's deemed legally to have never occurred, that he is able to say no. So I think that would be his understanding, and that's what I understood when I spoke to him in prepping for today's hearing. But to that end, I would also point out that that offense was 22 years ago with a non-party. So I would point that out. As to the court, Ms. Hurd's...
Was he arrested? Hold on a second, Mr. Phillips. Was he arrested for domestic violence with you, ma'am?
No, he
Okay.
was not arrested for that one.
Okay, go ahead, Mr. Phillips.
Sure, Judge. So I would pair those two things together in that you're looking at an offense with a third party who is not Ms. Hurd that was more than 20 years ago that's been sealed. So from Mr. Opapari's perspective, he has been instructed by the district court in a prior proceeding that he's able to truthfully say no when asked about that criminal history. Okay. So in no means does he come to Your Honor's court looking to deceive Your Honor or to deceive the TPO court or to hide anything. He's genuinely operating under the belief that because there's an order that says it's sealed and deemed to have never occurred, that it in fact has never occurred.
Why does he feel like he needs a protective order at this point, Mr. Phillips? I do think a lot of these things were addressed through the divorce case. I mean, I'm not sure that one incident where she's at his significant other's place of employment is sufficient for this court to maintain a protective order.
Sure. So obviously he's not here, so it's a little bit of substituted judgment because he's not here this afternoon. But my understanding from speaking to him is that it is part and parcel of the behavior that my office and myself personally is experiencing from Ms. Hurd. Now, obviously, legal process itself can't be harassment. I understand that, although Ms. Hurd has made that argument to the court this afternoon that, we're harassing her by having an appeal and this and that and another. But the reality is,
I didn't hear her say, so I just want to make a record that that's not at all what I heard her say. She said that her case is on appeal.
Right. But
I think you filed the appeal.
I did.
She filed the appeal.
We are harassing her with a number of proceedings by pointing out to the Nevada Supreme Court that her appeal was improperly docketed and now she's having to redo it, which is true. The Nevada Supreme Court issued an order on the 23rd of this month, striking her fast track.
No, I think she said that this protective order application was harassment, is what she indicated.
Well, and even if so, I would argue that a legal application, a legal process can't be harassment, right? Because it's properly filed with court. Now,
well, I would disagree, having sat in TPO court for 3 years, but go ahead. I certainly can see that abuse of process could amount to harassment, sir, but go ahead.
Well, I would understood, Judge. But the fact of the matter is, I know that as co-counsel, and as Your Honor knows, Mr. Friedman's actually primary counsel on this case. He's out of the jurisdiction as well. But nonetheless, I know that I personally have received not less than 20 separate communications from Ms. Hurd since October demanding that my office instructs Mr. Opapari to violate the existing court order regarding custody and visitation. She has sent me not less than 9 emails and then sent separately another 9 or 10 letters via the Odyssey eServe system. So
I like the judge.
Multiple times a week, if not weekly basis, we are getting demanding letters and demanding threats from Ms. Hurd saying that we have an obligation to disregard the court order that Judge Henderson issued regarding family first and visitation. And so Mr.
I agree,
Opapari's
Brad.
concern is that if she's treating my office that way, with this TPO in place, how is it going to escalate if Your Honor dissolves us? Because the only reason why she's not showing up and she's not contacting my client directly with those demands and those threats is because she's sending it to my office.
What threats, sir? What threats? Mr. Phillips, what threats are you talking about?
So I know on multiple occasions she has said to our office, or not to my office, I know she has sent Facebook messages and videos that she has posted. I know that we take we see the facts quite differently with the video, the video flash drive that Ms. Hurd mentioned. When you look at those in sequence, which I know Mr.
What threats? You're not answering her question.
Friedman addressed with you at the last hearing when you issued this TPO. What actually occurred in sequence is Ms. Hurd was actually following my client around, videoing it, and at the end of that video would then coincide with Facebook posts where she makes threats that she would end both her life and the child's life if she didn't get her way or get the visitation that she wanted with the child. And then in turn, she would make it a point to send repeated letters demanding that we provide her with unsupervised visitation, saying that she was not going
Okay,
to
Mr. Phillips, I just want to make sure that I understand. So where is that video, sir? That she threatens to end her life and the child's life.
This is a lawyer that just said this to the judge. A lawyer can't just say things like that to the judge if they don't have proof.
It was not a video, it was a Facebook post, and that was submitted in support of our initial TPO application. The court has those from the initial filing.
Well, I don't have any video I don't have any video.
I believe it was a screenshot, Judge, where she actually posted a comment, and we submitted that as an exhibit to the initial TPO application that was filed. And I believe my review of the record is that basis of Ms. Hurd threatening that is what prompted Your Honor to issue the TPO in the first place, because Your Honor had made the finding that you weren't going to extend that to my client's significant other or her children, but that this court was concerned about the veiled threats to the child at issue. And that's what prompted Your Honor to issue the order saying that you would keep an order in place to maintain no contact between these parties and directed that the parties maintain custody and visitation as directed at trial. And I would point out further that Ms. Hurd mentioned that, she's just here trying to fight for her child, yet she couldn't be bothered to show up for trial. She's in the position that she's in, making the demands that she's making, having been afforded the opportunity for trial and chose not to participate. So,
none of that is domestic violence, though. Mr. Phillips, you're really arguing apples and oranges, sir. I'm trying to focus on domestic violence. I don't care whether she showed up to a trial or not. I literally do not care.
I like to focus on domestic violence too. Where's my son?
Well, respectfully, Judge, I don't know what else I can tell you other than the fact that this court already issued a TPO based on the very communications that are still at issue today. And then when she was served with the current TPO, she immediately began demanding, saying that she would not agree to use Family First. She will not use Talk to Parent. She will not facilitate any supervised contact or visitation with the child, which I would point out is a violation of your order, because your order says the parties have to communicate via Talking Parent, and your order says that they have to.
But she hasn't. Okay, but she hasn't. Okay. Has she violated the order? Has she tried to communicate in a different manner with him other than through you and your office?
Not since the order was
Thank
issued.
you. Okay, please don't argue that she violated the order by refusing to communicate with him. Okay, that's just, it's intellectually dishonest by saying that she's violating the order. She hasn't violated the order.
She
a
called
violation
you
of
a
the order would be
liar.
going outside of my order and refusing to use Talking Parents as a mechanism for communication, but then trying to do it in some other manner. That would be a violation of my order. Not communicating with him is not a violation of my order.
Okay. Well, I respectfully disagree, Judge, and I would note for the record that
Okay.
your
Thank
order
you, sir.
says she has to follow the existing family court order regarding custody and visitation. And the communication that she has sent to my office where she expressly states she will not do so, I would argue that that is a violation in and of itself.
Okay.
Because I have it in writing where she says, despite the fact that Judge Henderson and Your Honor have said there's
Suda, we haven't even heard anything yet. Why are we putting this child in a foster home?
going to be visitation parameters, she's not going to follow them.
Okay. Okay, so what is so I issued the order based upon the testimony, but I am looking through the additional exhibits that were provided. Where is it that she threatens to kill the child?
If you give me just a second, Judge, I will pull it up for you. Forgive me, I am... I'm scrolling through our initial application. Give me just a minute, Judge. So it would have been...
It's a very long document.
Yes, I know. I'm...
Too long, didn't read.
Oh, and then this isn't the answer to your question regarding threatening the child, Judge, but I will remind the court as I'm scrolling through that Exhibit 4 to our initial application actually is the photographs of the tracking devices that Ms. Hurd put on my client's vehicles. And Ms. Hurd even admitted to you today that she has criminal charges pending as a result of that behavior.
He didn't prove that yet.
Photographs of the trackers themselves were Exhibit 4 to our initial motion, but also point out
When was that
that
from?
in Exhibit 4,
When was that?
there are, I would have to look, Judge. I'm not counsel for Mr. Okaparty in that matter. I know the case is still pending with a status check on negotiations. I believe in late January is when Ms. Hurd's next criminal court date is. But we're not representing Mr. Okaparty in that case, so I don't have that readily available. But the photographs in Exhibit 4 do show, it looks like the child's diaper bag, where Ms. Hurd also looks like opened up a scene, put in a surreptitious recording device, and was looking to utilize some sort of inappropriate recording mechanism, and then looks like, let's see, and then if you look at Exhibit 5 to our initial motion, there's a series of Facebook posts from Ms. Hurd where she showed up at an event without supervision, took the child away from my client, walked off with her, which, by the way, she was required to have supervised visitation, and then after there was an altercation about that, there's a series of Facebook messages where she says, family court's the problem. She's not going to be silenced about the abuse that the court's putting her through, and that she has to speak up. And then I'm still scrolling, Judge. And then I'm looking for the specific.
So you're saying that these pictures, well, who took these pictures? I mean, there's...
My client did.
Oh, there's tons of...
He was there with his significant other at an event with the child. And that was a scheduled event for the child. I believe it was a baseball activity.
And these are evidence that she wasn't supervised? There's like 20, 30 other people in the... Okay, anyway.
But she is supposed to be supervised by family first.
No, I get it.
There's
Okay.
specific-
Anyway.
right. So she's
Anyway,
showing up and
moving
taking the
on.
child
So
away
where does she threaten to kill herself and the child?
That's how I like my men looking.
I'm still
Uh-huh.
Yeah, me too. Because I've scrolled through it like, I don't know, 10 times now, and I haven't been able to find it.
It was a veiled threat. It wasn't explicit, Judge, but
And when was the tracking device from? When did that occur?
was the end of last year. If you'll give me,
Oh, the end of 2021.
I can look. I'll have to pull up the Justice Court, Henderson Justice Court.
It's okay. It's okay. I'd rather you just find the place where she threatens to kill the child and herself.
Understood. Okay. Happy to do that, Judge.
He won't find it. If he actually had that, he would have had it ready.
Let's see. As I'm still scrolling, Judge would point out too that there's photographs of Exhibit 8 to our application where she's following my client through his neighborhood and following him and his significant other, which I know the court didn't issue the order as to his significant other, but the fact that she's taking pictures and following him through a neighborhood is also quite concerning when she's not allowed to be. She wouldn't have any reason to be there for a custody exchange, given that it has to be supervised.
When was that?
The date.
So I understand you hate women. I'm sorry.
Unfortunately, they're not dated, Judge, because it says yesterday. It was a screenshot of my client's camera reel. It says yesterday at 2:54, so that would have been at or near the time of the TPO application. Because the camera on his iPhone just dated it yesterday for the day that he took it. So roughly 3 or some weeks ago, at the time, at or near the time of filing, because that would have been in support of the initial application. But again, she wouldn't have had any legal reason to be following him around, given that she would have had to have supervision to do a custody exchange, and cannot. And then let's see. Let's see. And then, unfortunately, Judge, I don't think I will be able to get you the actual thing that you're looking for this afternoon, because it looks like in whatever issue the court's having in uploading the digital exhibits, it would have been there as well because...
Did you submit digital exhibits?
I believe we did at the time of the initial application, Judge, because I had personally seen this, and apparently what Ms. Hurd had done at the time is she had posted a photograph of the child on her Facebook page and then captioned like one of the 10-second reels or whatever with a veiled threat about how life would be better, it maybe would be better if she and the child were no longer here or was no longer able to be contacted or in any way have communication or contact with Mr. Opamari. So to be completely candid to the court, it's not a direct threat. It does not say I will kill the child, but it is a part and parcel sort of veiled attempt that when you piece together the videos of her following my client around that she mails to him with a chronology, you piece that together with the photographs of the tracking devices that he found on his vehicle, you piece that together with the fact that we have the photographs of the tampered diaper bag, piece that together with the fact that the city attorney in Henderson thought that her behavior rose to a criminal level, right, because she's facing criminal charges for that conduct. And then you piece together the fact that she shows up to take the child physically from my client without supervision. And then you add on top of that the fact that, no, to Your Honor's point, she has not said, she has not directly contacted my client in a direct violation, but she has sent communication to my office repeatedly saying she's not going to utilize Family First for supervision. She's not going to utilize talking parents, which is what this court and Judge Henderson both ordered. And so it is a cumulative effect, Judge. There's not one single precise thing I can put my finger on for you. It's the weight of the pattern and practice of Ms. Hurd's conduct that is concerning to my client, because he comes out of his neighborhood and she's there. He takes his daughter to a softball game. She shows up without supervision. He has my office send a letter that says, hey, if you want to arrange visitation, you can do that, but it needs to be supervised. She says, I'm not going to do supervised visits.
Okay, all right. I've heard. I seriously, I've heard enough about the visits. That's not what I'm trying to prevent. Again, like, I don't care if she showed up for the trial. I don't care if she's visiting. That's not an act of domestic violence. I'm trying to figure out what the domestic violence
But
is.
just
And
talking and harassment.
okay, well, I'm trying to ask you again. When is it that you allege she was stalking? The stalking. When did she follow him? This is why your client needs to be present for hearings, right? This is why, because he could answer these questions. I don't understand why your client is not present today. It doesn't seem like he has. I had difficulty getting him involved in the initial hearing, and now he's not here today. She's asking to dissolve the protective order. I would think that he would make this a priority.
I understand, Judge.
Well,
I mean, obviously, I can't speak for why he's not present.
I know, but here we are arguing that her sending letters to your law office is an act of domestic violence, right? This is what I'm left with today. All right.
I love her.
Do you know when the picture was taken of you?
Do not answer that.
allegedly following them around the neighborhood?
Do not answer that.
There's a lot.
That's a really simple. That's a
Okay.
really simple question.
Yes, and I
So what
addressed
was the
that in
date?
my motion.
Yeah, I know.
It's April.
So you could have me look over the
This
25-page motion
One
again, or
picture that they're referencing right
Yes,
now is from
that.
April, and I wasn't following them around. I literally,
I do not know who the bad guy is either. We're going to find out.
it was April 2022.
April of 2022.
And I was documenting who was taking my daughter to her therapist because he, as Mr. Phillips is stating, Mario's always there and I'm doing this with Mario, this with Mario. It's not. It's Carrie. Mario's abdicated his rights to Carrie. He's not doing any of the parenting. And that's one of my arguments. I know it's not for this court, but that's one of my arguments is that my daughter's gone from
And
one
when was
parent.
the tracking device
They
incident?
filed a complaint September of 2021.
The Henderson,
Yes.
they filed the complaint in September of 2021.
Yeah, so over a year.
Is
ago.
it Henderson Municipal Court?
Yes.
Or
Henderson Justice Court. And
Is
I,
it under?
It's just thinking about it. You thought about sending a letter to me, so you've already domestic violence to me. Don't do that again.
Opapari, or is it
my name,
under?
Hurd, H-U-R-D.
It is under Hurd.
Yep. And
I
Kimberly,
can't
so just do
find
Kymberlie, and then my last name, don't do my middle name, and I think it'll pull up.
Judge, if it helps the court, I have a case number at Henderson Justice Court.
Okay.
I actually included it in the exhibits.
Oh, you did include it in the
I
exhibits.
had nothing
You're
to
right.
hide, so.
She did include it in the exhibits.
She did, Judge. And it was actually filed, the criminal complaint was filed April 14th, 2022.
Their complaint was filed September 2021.
When you say their
Looks like it.
complaint, ma'am, who are you talking to?
Mario.
Oh, Mario's complaint.
Yeah, he initially filed it with Henderson in September 2021. Henderson, City of Henderson, filed their complaint, formal complaint in April.
I understand. Yeah, I just don't, I really just don't have a basis to make a finding today that there's an ongoing threat of domestic violence. Ms. Hurd had filed her motion to dissolve this protective order on December 9th of 2022. It should have been set for a hearing by December 16th of 2022. It was not. It was instead set for today's date, December 27th. Mr. Opapari has had more than sufficient notice of today's proceedings. He's opted not to participate in today's proceedings. The stalking incident or the incident with respect to the tracker, counsel
Yes.
indicated that
Yes.
that happened at the end of last year of 2021. Ms. Hurd indicated the same. She said that Mr. Opapari made that complaint in September of 2021. I don't even think that there is a method by which she could continue to track Mr. Opapari at this point. She's not having access. She doesn't have access to the child. or maybe she does have, I don't wanna misspeak, maybe she does have access to the child, and maybe she's not taking advantage of it. Nonetheless, it's clear to me that at this time, she's not having, visitation with the child, whether that's on her or whether that's on him. That's an issue that, needs to be resolved by a different court. As for the following, in the neighborhood, the court, was under a similar impression after having reviewed everything. Unfortunately, I reviewed everything prior, to the long, holiday weekend, and there's just pages and pages and pages and pages of exhibits, and pages of documents that have been submitted by both parties.
Look. There's a mankini on that dome. Another Smith, thank you so much.
I barely issued this protective order when I did, on the date that it was requested on November 18th. I issued it in an abundance of caution. There were a lot of things that were brought up during that hearing that were not fully argued in the application itself. And so the court had a lot of information before it that day, and in an abundance of caution, issued the protective order on November 18th. The court doesn't find that there is an ongoing threat of domestic violence, and the court doesn't find that there's any imminent threat of domestic violence at this point. Many of the allegations that are contained in the application were many months old, and the court is not convinced that the adverse party's refusal to use talking parents or our family wizard amounts to harassment. So the request to dissolve the protective order today is going to be granted. The request to extend the hearing on the applicant's request to extend is going to be vacated, so that January 4th, 2023 date will be vacated. The motion, or the order will be immediately dissolved, and the case will be closed. All right, thank you, Mr. Phillips. Thanks for making an appearance. I'm sorry you had to do it by phone. Have a good day.
No, that's okay, Judge. Thanks so
All right,
much.
thank you. All right, bye-bye. Case closed. Ma'am, well, I have to do fine.
The court only has so much.
So, apparently, unfortunately, there's one that was out of order. I think it's this one right here. Yeah. So this one was in November. This was in November. The one we just saw was in December. So we're going to watch this one. This one is technically the first one. It's, yeah. And then we'll go back to the list in order.
For a protective order.
Yes, ma'am.
Hold on one second. I've got your attorney on the other line. Okay, Mr. Friedman, I have Mr. Opapari on the phone. We are on the record T22-22970.
It looks like she didn't show up to this one. Maybe.
1T, the matter of, well, the way this is written, it says Mario Opapari and Carrie Anderson versus Kimberly Hurd. This is the time set for the court to consider the request for a protective order. So let me just start out by making a record that this court is unable to hear requests for protective orders between people who are not related by blood or marriage, or who don't have children in common or not in a relationship. So Carrie Anderson, the court doesn't have jurisdiction to issue a protective order for in favor of Carrie Anderson. So the court will have to consider, and we also can't hear applications for two applicants. The court only has the ability, so if Ms. Anderson wanted a protective order, she would have to file separately in our court, but we don't have jurisdiction, so she would need to go to justice court if she wants a protective order against Kimberly.
For expedience's sake, obviously with what was going on, we tried to get something in front of the court, but understand the jurisdictional issue. I just by way of explanation why we did that, and due to the fact that she has a young minor child, but understand certainly where the court's coming from, and I can discuss that with my client after the hearing.
Okay, so and I'm so sorry, counsel, I didn't have you make an appearance for the record, but let me have you do that real quick.
Absolutely. This is Matthew Friedman, 11571, on behalf of Mario Opapari. Obviously, also counsel for Carrie Anderson insofar as we've included her in the application, though I do represent Mr. Opapari in his family case and in the pending appeal filed by the adverse party, which is obviously divested the district court of jurisdiction on these kinds of matters.
So I mean, I read through everything here, counsel. I'm just not sure how I get to domestic violence on this.
I think from our perspective, it's the stalking and harassment, Judge. So it's the knowing that you know what the orders are and showing up at Mr. Opapari's fiance's place of employment. I understand we're not considering Carrie today, but showing up at the place of employment, contacting his employer, and going ahead and attempting to sour him in the workplace, sending in the mail to him a hard drive containing a series of surreptitious recordings and surveillance footage.
Was that not discovery or no?
No, that's not my understanding. And in fact, she's actually already being prosecuted separately in a criminal matter for similar surreptitious recordings and surveillance. So so the presentation and the timing of when this was after.
I'm sorry, counsel. Go back. There's a lot of background noise. I'm so sorry.
Sure.
So
That's okay.
she's being prosecuted for.
She's being prosecuted, right, for making these surreptitious recordings of them sewing devices into the child's bag, and recording them, and obviously she's being prosecuted criminally for those, and those charges are still pending.
Is that in justice court? Do you know?
I believe so. Yes.
Hold on 1 second. I have access to some criminal stuff. I don't have access to everything, so I was just trying to.
I can certainly pull it to Your Honor. I don't have it sitting right here in front of me,
That's
but I'm happy.
A green mankini with my green screen would be hilarious.
If you want to take something.
That's okay. You don't have to. I was just curious if you were. Okay, go ahead. Sorry.
So that's going on. So then, obviously, pulling up next to, Mr. Opapari and Ms. Anderson in the vehicle routinely, and sort of smirking, smiling, and these aren't coincidental run-ins, right? They're repeated, they're persistent. So it's an engrossing pattern of stalking and harassment.
Did I miss that? I'm so sorry. Did I miss that? So tell me about that.
So what the adverse party doing?
Why don't we have your client tell me? Let me have him raise his right hand. Sir, Mr. Opapari, can I have you raise your right hand to be sworn in, please, sir?
Yes, ma'am.
Thank you.
You do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, I may have missed that. Tell me about that, about the driving up and what's going on?
Is that for me?
Yes.
Yeah, I think she wants to hear it from you, Mario.
She's in the past. She's been court ordered by Judge Henderson to stay away from my residence unless I invited her over there. There was a time where she came to my residence, caused a scene. The cops had to be called. There was another time that she was driving down the road and just happened to pull up next to my fiance Carrie at the light and was smirking at her and all that stuff. And she's
When did that happen?
abusing us. I don't remember the
So
exact
you
time.
weren't there. Okay. All right. Gotcha.
I wasn't there, but
Okay.
and then she's been verbally and abusing us and saying some things on social media that are very I can't think of the word for it, that are grilled towards us without mentioning our name. Like you'll see me before you see God if you do this, if you do that, and she does own a gun, and both of us are worried for our safety because she claims she has a mental illness, and she's an...
Okay, I thought there was, I'm sorry, counsel, I thought you were suggesting there was a pattern of her showing up where they were driving and, okay.
Well, she does, that's my understanding of what Ms. Anderson and Mr. Opapari told me. I mean, forgive me, Your Honor, Mr. Opapari works in automotive mechanics. He's not an attorney or a skilled orator, and I think it's probably a little disconcerting for him, to kind of jump into it. But we briefed for the court some of the
True.
signs of her showing up at Carrie's place of employment because Mario's truck's there. Obviously, this is in the middle of the evening on October 19th. She's showing up and loitering around the parking lot and loitering around Mario's truck. Now, Mario happened to not be there, but it was his truck, and that's what she was loitering around. We've shown you photographs of tracking devices placed on the cars that she's done. We've shown you the thumb drive that she delivered October 22nd. A video recording she's taken while surveilling them without their knowledge. And October 22nd, 22, the case is closed. Like there's no, it's not an exchange. And so we mirror that with what Mario was trying to allude to, and we attach some of those. These social media posts where she basically is directly calling them out, basically indicating, they'll be the last people that, she'll be the last face they see before they meet their maker, before they see God, for basically taking her child away, right? That's what's going on, right? The orders of the court are sole physical, sole legal. Now, with respect to the minor child and the nexus there's an order for supervised visitation. She has no set visitation, right? Is she supposed to do all of her visitation through Family First? She refuses to do that. What she does is she shows up to events, and we documented this for the court. She shows up and just takes the child's there with Miss Anderson, takes the child into her arms and basically proceeds to walk away. And then there's nothing that can be done. So Carrie has to follow her around this complex until finally, she relents and releases the child back. It's a direct violation of the order. The major problem that we're having, too, is because Ms. Hurd's taken appeal, I have to go in and seek a remand to even try to enforce the court's orders. So it's not that we're not going to do that, Judge, but it's very difficult for me to do that in any expedited time frame. And so when she's calling his work, when she's driving past their house, when she's driving past where she knows they live, when she's showing up at his place of employment, loitering around his car at night, right? When she's calling, his employer and speaking about him, she's posting these concerning things. We're just saying, and to be fair, there's also a behavior order issued by the court. I tried to get that reduced to writing. I wasn't counsel previously, but I know it's in the orders and in the minutes. So I can't even go and enforce that right now because I don't have jurisdiction in the district court, right? And so what I'm looking to do is get a protective order that until I can potentially get a limited remand to address maybe, the emergent issues, which is this person's continued unraveling, following, her not showing up for trial, not taking a drug test, not showing up for trial, and now basically blaming the applicants, I understand we're not considering Ms. Anderson, for, the demise of her relationship with the child. And her behavior is growing more and more erratic. And it's like, I don't know, I understand she hadn't, shown up and pulled a gun on Mr. Papari or something like that, but it's like, how far do we go before she does? And right now, there's just no recourse that he has to go like, hey, she's driving past my house, can you stop her from doing it? Right? She's driving past my, fiance's place of work, and she's loitering around my truck, and if there's a protective order in place and she continues this behavior, we at least have a prompt recourse.
Okay.
And I would say there's no
I'm convinced.
from her.
All right. I'm convinced. Okay. All right. I got it. All right. I'm going to grant the request for the protective order today. I do find that there is a sufficient basis to make a finding of stalking. The order will be issued today. Counsel, I could do, so this is probably really bad. I can do I can do the week between Christmas Day, or I can do the week after Christmas Day. I don't know if you're going to be in town, Counsel.
I'm not, unfortunately.
What about the week?
Our office is closed.
What about the week after New Year's Day?
If it's later in the week, Judge,
I could do it
probably.
I can do it the 5th, or I could do it the 3rd, the 4th, or the 5th.
Sorry, court's indulgence. I appreciate it. I'm just trying to get my calendar work here. It looks like the 4th is going to be the best for me.
It's in the morning, so 9 o'clock. Does that work?
Let's see. That's in person, correct?
Yes.
Yes, that's fine. 9 a.m. on the 4th.
January 4th at 9 a.m. All right. Between now and then, Kimberly will be prohibited from having any contact with you, Mario. That's phone, text, email, social media. He'll be prohibited from, or she will be prohibited from going within 100 yards of the residence. That's 249. Is it Hyssop Court? Hyssop Court, Henderson. the, your place of employment shall be prohibited from there. I'll put down, PTs as a place that you frequent.
Yes, thank you.
Jason Anderson's home. CT Sewell, she doesn't have any right,
So it sounds like in the one that we watched before this, that happened after this, she did break that protection order. But the attorney was so focused on all this other crazy stuff that he didn't say. You know, on October 15th, she was at his job. But I think it was, what was it? It was only electronic. Like, it was just messages that she posted, right? She didn't actually go see the husband. She avoided seeing the husband and was just sending messages to the attorney, which is not breaking the protective order. But the post that she put on social media was actually breaking a protection order.
right now to go to the schools, right? I mean,
No, she has no legal. She has sole physical, sole legal, solely supervised visitation at Mr. Papari's discretion. That's
so CT Sewell Legacy Traditional will be prohibited addresses. And then I'll just put that the custody order in D21 622-669C will be the order of this court.
okay. And with respect, that will apply for Aslan as well. You're just not able to grant it with respect to Ms. Anderson and her child at this time, due to the court's jurisdiction, correct?
So Aslan's not a protected party. She's not a protected party, but the custody order would stay in place. So, and I'm sorry, you said you wanted communications to be through talking parents or for non-emergent. Okay.
That is the court's order that she's continued to refuse to apply with, but that is in the decree of divorce prepared by Ms. Crone following the trial.
Okay, so I just want to. So what I'm going to do is I don't want to issue conflicting orders because you know how that goes.
Of course.
So we'll say communication with Mr. Opapari by Ms. Hurd will only be through talking parents or any non-emergencies would go through you, counsel?
That's fine.
That's what the request was here in the.
That's fine.
Okay.
That is fine.
Any non-emergencies.
And that's the only bit that would not already be governed by the decree, but obviously is an additional term that I think makes sense in light of, you know, if she has some necessity to convey something, she can convey it to me through the office, and I'm not in need of protection from her at this point. So I think
Maiko, you gotta dang it.
that's more than reasonable.
So she hasn't used any of her supervised visitation at Family First since August?
She's refusing. I mean,
Okay.
candidly, just so you have the context, and I've spoken with Ms. Hurd, and so I can you know, obviously state as an officer of the court, you know, this is my summation.
I believe you.
She basically said she doesn't. I know, but I'm just for the record. She just doesn't. You know, she's refusing to use talking parents, and she's refusing to use Family First. And she's called me to ask me for visits, and I said, listen, the order is the order. If you would please sign up for our Family Wizard, you can make these requests there, and absolutely, once you're engaged with Family First, I will discuss with my client. We will arrange for visitation, and she just won't do it.
Okay.
Instead, just is persisting with the conduct that brought us before Your Honor today.
And just to be clear, counsel, and this is not, I'm not trying to correct you or anything. Is it talking parents or our Family Wizard that they use?
It is talking parents.
Okay, talking parents. I just wanted to make sure. Okay, okay, all right, great. So it doesn't specifically, like, I can't make.
He said that they were in evidence, but then he could not find them. So
Kimberly, and I can't make her daughter protected parties. Aslan is not a protected party. Yeah.
Oh, Aslan's not, even though she's the subject matter child?
She's not protected in that the finding isn't that mom committed an act of domestic violence against the child, right?
I see what you're saying.
So mom can still have contact with the child if she goes through the correct mechanisms to do so under the
way to have it is, because this is what we're looking to stop an operation. I appreciate what the court's doing, and I know you're constrained by certain mechanics, and I certainly get where you're going. The concern is, if the order can simply state that certainly it's not a violation of the order for mom to arrange for and try and facilitate visitation consistent with the decree, fine. But it's mom showing up to a place. So their daughter has some special needs. She's and so as a result, she's involved in some organizations and participates in events. Now, mom knows about those events because mom, is on the social media groups, whatever. So mom will just show up. Miss Hurd will just show up and just essentially, in violation of the court's order, take the child into her custody. Now, she hasn't as of yet put the child in the car and driven away, but it's still completely contradiction of the decree of divorce, what the court's orders are, and I would argue, it's tantamount to the same sort of pattern of stalking harassment. And that's all I'm looking to. Just some situations. I suppose if she shows up and Mario's there, it's a violation of the order because she's there if Mario's there. But if she's there, for example, with her grandparents, or if she's there, with Miss Anderson.
Well, let me just ask you this: is there anything between now and January 4th?
That's a good question,
Mr. Opapari, that should be specifically excluded because it's easier for the court to make specific orders instead of
that's a great question.
general orders.
It's hard to say. The only thing that's now between now and then, I do have a couple softball tournaments in town that they get posted all over social media.
Those are Aslan's tournaments, correct?
No, they're my tournaments, but Aslan would be there.
I see. Well, if you're there, Mario, then it would be a violation for her to be present because you are there and you are a protected party.
And I know we're supposed to have an end of the year banquet or whatnot for the Miracle League. I have not gotten confirmation when that will be.
But you'll be there, right?
Yes, I'll
so
be
you're
there,
the protected.
Okay.
Yeah. Okay. That's the question, Mario, is just making sure that if you're there, I think what the court is indicating is the protection is going to flow from this order. The issue would be is if you're not present, for example, for the Miracle event that you're referring to, and obviously we know Ms. Hurd's going to know about that event, and she shows up, there's not Carrie, for example, Carrie, or let's say your parents aren't going to be able to use the order.
Okay.
Yeah, so that it could maybe include just a Miracle event.
Is there a softball field that you typically play at, sir?
We play all over the Valley, man.
So there's not one that you use primarily.
I know December. I know the next tournament I'm playing in is December 4th and 5th, and that's at Desert Breeze.
Desert Breeze, perfect. I'll make it a prohibited location. Anything else?
Okay.
I can't think of anything else, ma'am, that she would be going to without me at this time of year.
Okay.
Between now and the 4th. Okay, perfect.
I'm just trying to cover bases until we can come back on the 4th.
I appreciate it, Judge.
Okay. All right. Great. I'll issue the order now. We'll email it to you, counsel. We'll get it sent out for service on Kimberly. Mr. Opapari, if Miss Hurd shows up at your residence, if you see her somewhere, you can call the police, let them know you have a protective order. They should be able to come out and serve her on the spot if they can make contact with her, okay?
So, how does that work with text messages, ma'am?
I don't even cover my base, more or less my bases.
She continues to blow me up on my text messages.
Oh, when she's served, make a police report, sir.
Okay.
Absolutely.
Make a violation if she violates the terms, I think, of the protective order. The judge is saying that's your recourse is we notify law enforcement, and that is a formal violation of an order.
Right. Right, because we're going to limit her contact with you to talking parents. So let me just, Mario, can I just get an email from you also? We're going to email you a copy of this order as well.
Oh, it's my last name, Opapari.
No.
O-P-I-P-A-R-I.
Okay.
53
Okay.
at yahoo.com.
Great. We'll get this out to you both. I will see you both on January 4th, okay?
Thank you, Judge.
Thanks
Have a
for answering my
wonderful
question.
holiday.
You
Good
too.
talking to you.
Also. All right, thanks. Bye-bye.
We're ready on Opapari versus Hurd.
I'm just looking through the Hey Brayden. Just looking through the dates real quick. So we did December 27th. This one is the whole way in March 2023. March 21st. Part 2. This is part 1. So this would be the next one. November 23. That's the one we just did. Oh, this is... Guys, these are like absolutely not in any type of order. They start to be in order later. January 24th, part 14, part 13, part 12. So they start to be in order here. To get there, we have to, all right, that's 2023, 2023. This is August of 2022. This is part 1 of August of 2022. I think I saw 2021 in here, though. Alright. April of 2022. Alright, there's November of 2021. And this is June of 2021. This is the furthest back one.
We're ready on Opie Powery versus Hurd D622669. So sorry that we're already running pretty late this morning. Pretty intense calendar. What appearances do we have, though, please?
Good morning, Your Honor. Shaka Chrome on behalf of Mario Pipari, bar number 8116.
Excellent. And let's have our additional, let's have Mom's appearance, please. Where is she?
We can't hear you.
Amanda Roberts, bar number 9294. On behalf of the defendant, Kimberly Hurd, Your Honor, I'm appearing on behalf of Jason Stoffel, 8898.
So she has a lawyer here. Yay!
Yes,
Yeah.
Nevada.
And although I'd rather not do this on the record, but I'm very, very concerned about this. So how is Mr. Stoffel doing at this point?
Your Honor, he's been released from the hospital. He's at home. It's going to be a very long recovery process because he was hospitalized almost 3 weeks.
No, that's great that he's home. I'm so relieved.
But he's home and he's able to communicate and he's getting the treatment that he needs, so that's the good part.
Oh, that's fabulous. I'm profoundly relieved. And and we'll move on to this matter.
Your Honor.
Has Down syndrome, correct?
Ms. Chrome and I actually have come to some agreements, Your Honor, if we could put those on the record.
Let's get those first, since that'll really
Okay.
streamline everything.
So we've agreed to joint legal custody with a specific definition. We've agreed to a behavioral order. We've agreed that exchanges will take place at the Henderson Police Station. We've agreed that the 4th of July will be with the plaintiff in odd-numbered years, defendant in even-numbered years. It will be defined as July 2nd at 5:30 p.m. until July 5th at 5:30 p.m. Defendant's grandmother passed away, Your Honor, so she has a funeral with her family members from July 6th through July 8th, so she will exercise that time with the child to take part in the funeral. We've agreed that Ms. Chrome and I will have a meet and confer next week regarding the child support issue. We've agreed to a senior judge settlement conference. I'm sorry, Your Honor.
I said excellent.
Okay, we've agreed to recording exchanges, and we've agreed to talking parents, Your Honor. There are 2 things I believe that we need the court to rule on today: the response time for talking parents and a custodial schedule between the parents. And I think we both have proposals, if the court could just hear from us on a limited basis on those issues.
I would mention that I think most of those agreements are excellent. I do have some concerns about recording the exchanges. That tends to lead to a lot of tumult. I hope you're indicating that all exchanges won't necessarily be recorded, but that if something untoward occurs, that the party would have the right to record the next one. Or do they really intend to record the exchange?
So right now, Your Honor, I think Ms. Chrome and I believe that they are still in the high conflict, and hopefully as this progresses, that the recordings will be limited.
Okay.
But they tend to be in a little bit of conflict right now, and I think with these specific orders that we've agreed to, it may help reduce the conflict. and maybe with the help of a senior judge, it can reduce the conflict even more. So
I called the bank, Fozzie, and I told them there was fraudulent stuff on your card.
I think right now the intent is that they will record, but as time goes on, they would not record. And hopefully with it happening at the police station, everybody will be on their best behavior, which is the goal. And Shaka can correct me, or Ms. Chrome can correct me if I'm wrong, but I think that's the intent right now. And I think with those two limited things, if we could just argue the response time on talking parents and the issue of what the temporary schedule will be, then really what we just need, Your Honor, from you is a return date after the senior judge settlement conference. And if we can't resolve everything then I guess we would have a trial on my client's request for relocation and the final custodial orders.
Excellent. Before we start with those couple issues, we're checking now, we may be experiencing some difficulty with a close-in senior judge or even one through the judicial settlement conference, but the court has informal arrangement with several other judges where outside of both programs will refer cases to accept.
That's acceptable to me if it's acceptable to Ms. Crum, Your Honor. Either way, I will tell.
What I wanted to clear up is of those several judges who I've come to an informal agreement sending cases back and forth is Judge Ochoa. So I needed to check. I knew for a period, perhaps a relatively short period, there may have been a recusal from his department. I don't believe your firm is still on that, are they, recused?
We are not, Your Honor. We just had recusals on specific cases with Judge Ochoa.
Okay, very good. Okay, in the meantime, while we're checking on availability, go ahead and proceed with those two issues, Ms. Roberts, please.
Hang on, can I add just a couple more things? The first one is just paternity is going to be confirmed today.
Yes, that's accurate.
It's not.
And
it is accurate, Your Honor. He's on the birth certificate.
Perfect.
yeah. And then we've agreed that both parties will remove any posts from social media that disparage.
I didn't talk to her about that, and I didn't agree to that. We can talk about it in our meet and confer. I'm sorry, I didn't talk to her about that.
That's fine. Then
I'll put that on the list for the meet and confer.
But be aware that unless this case is an outlier, the standard order is, and from this court, is number one, have those must be removed immediately. And number two, if someone claims, hey, it wasn't me, it's some third party, the court most of the time concludes the person has control over the third party friend or relative who's posting adverse material about the other party. So this court goes pretty far in making people responsible for third parties. So just so you know that there isn't really a lot of suspense to how the court would rule if it's submitted to the court. But I would much, much prefer that the two of you include that among the other issues that you'll stipulate to, and that the court doesn't have to deal with it. Go ahead.
That's fine. I'll put that on the list for the meet and confer next week regarding the child support issues.
Okay, very good.
Thank you. And then the only other thing that I would say is that at the return hearing, we want to reserve our rights to argue any issues that haven't been resolved. So
I agree with that.
Of course.
For us, it's not just a trial on mom's relocation. We're reserving the right to argue that there shouldn't be a trial.
Sure.
Right.
In addition, after the two of you meet, if it's not successful, did you want to have a mediation? Well, we don't need one if there's going to be a judicial conference. So, Ms. Roberts.
They've already gone to FMC, Your Honor.
Yeah.
So the parenting plan that was drafted by FMC did not include all of their agreements.
Yeah.
And so it can't be entered. So I think that this is what we're doing in lieu of that parenting plan, Your Honor. And
The good thing is, this is going to make OJ sound fantastic.
then, and Ms. Crum and I work together. Maybe we can come up with a plan that will resolve the entire case, and hopefully with either a senior judge or another judge that'll resolve, Your Honor.
Yeah, because the June 14th, I'm delighted to hear that some agreements were reached, because the June 14th correspondence I received, FMC said they didn't agree on anything. So I'm glad that you have some agreements. But let's start with the temporary timeshare till we return, till the settlement conference, or at least, go ahead, Ms.
So it's Ms. Crum's motion, Your Honor, so I'll let her go first, and I'll just mute myself, and she can argue those two issues.
Okay.
Okay, great, thank you. So regarding the custodial time, temporarily we would agree to a joint physical custody, obviously reserving our rights to make any future arguments. And we are requesting from Thursday at 5:30 to Sunday at 5:30. But if a party's traveling, we want them to be flexible, so if the return is late, that there's not a contempt of court relating to returning late. They would just post it on Talking Parent and continue to exchange at the Henderson Police Department. And if I may, just regarding the exchange, what I would like to happen is that the parent who has the child remains in the driver's seat. The other parent opens the back door and just takes the child out of the back seat. And they don't communicate. They just post on Talking Parent until we can get to a mediation and resolve everything. I think it would calm everything down. And this child is mobile. It's not like, she can't function, but it would probably be nicer for a parent just to get her out of the car and take her into their car. So we're asking for Thursday through Sunday, 5:30 exchanges at Henderson.
Okay, excellent. Ms. Roberts?
So, Your Honor, we're not too far off, I don't think.
Could you imagine how fun it would be to try to get your child? I don't know what the age of the child is. It doesn't matter. Could you imagine how fun it would be to try to get your child to get out of your car and get in his car or get in her car while you're just staying in the driver's seat? All right, dear, you got to go now. Okay, you have to go now. You need to get out of the car. Get out of the car. Get out of the car right now. My kids would never get out of the car. Wait. I gotta fix my sock. It's not straight. Hold on. Now I can't get my shoe back on. No, you gotta get out of the car. You gotta get out of the car. You gotta open the door. You gotta yell. That's the only way the kids are going to get out of the car.
On the timeshare. So what we had proposed is Dad would get Friday at 5:30 until Sunday at 6, which is still joint physical custody. And then we had proposed one overnight during the week where he would get 5:30 and return the next morning when he goes to work. This is the issue, Your Honor. And the court said it at the beginning of the hearing. This child has Down syndrome. She is nonverbal. She uses ALS, so she does communicate simple words, but she uses some sign language, and she requires constant care. Although she is 5 years old, Your Honor, she has the mental capacity right now of about a 2-year-old. She's still in diapers. She goes to multiple not physical therapy, but speech therapy, and multiple doctor's appointments a week. She's on medication for hypothyroidism and allergies as needed. These parents need to be communicating very, very frequently regarding this child and medication and what's going on. And so as it relates to Talking Parents, Your Honor, we're asking for a 6-hour response time. And I know that is a very short period, and usually it's a 24-hour response time. But this is a special needs child, and we may need to keep up on potty training her and what's going on with speech therapy and what's going on with her medication and all of those kinds of things, and joint legal custody questions, Your Honor. Then it is absolutely necessary for us to have a short turnaround time. As it relates to the timeshare, Your Honor, Mom and Dad doesn't dispute this, Your Honor. When they found out that Mom was pregnant with a Down syndrome child, they agreed that Mom would quit her job and be a stay-at-home mom. So for the last 5+ years, Mom has been the primary physical custodian of this child. She has gone to every single medical appointment. She has gone to every single therapy this child needs. She has been the one providing the day-to-day care, Your Honor. So the issue is this. On Thursdays, Dad got the child overnight and kept the child until Friday morning. Fridays, our question is who would care for the child? Because it has to be someone that has the ability to, number one, have a relationship with the child to understand her communication, who is physically capable of changing her diapers, making sure that our medications are given. So our proposal, Your Honor, was a first right of refusal. In the interim that does not work, Your Honor, then what we'd ask is that his overnight actually be on Tuesdays, and he would get Tuesday at 5:30 until the next morning at 9 o'clock exchange. And the real reason, Your Honor, is that what Dad is proposing is that his new girlfriend would be the caregiver of this child. And when Mom is available for a special needs child, it is our position, Your Honor, that the Supreme Court has ruled on those issues and said that mom has preference over these third-party caregivers. And in a normal situation, Your Honor, when the child does not have special needs, I understand the court would typically not have a parent, would not typically interfere with this, but this is a different situation because of the special needs that this child has. So those are the things that we're asking for, Your Honor. Talking parents response within 6 hours, and that either if dad wants Thursday until Sunday, my client is agreeable if she can have the time during the day when she is available with the child. The child does go to extended school, Your Honor. That starts in 2 weeks. The dad drop her off Friday morning at school at 9 a.m. She gets out of school at 11 a.m. So my client would get her from school and keep her from 11 until 5:30 when dad is out of work, and they would do the exchange at the Henderson Police Station. Our proposal regarding the exchange, Your Honor, which might cut down on the talking parents communication, is that they simply have a journal that they exchange. The journal documents the things, what time did she last receive her medication? How is the potty training going? How is it going regarding the therapy that she's supposed to be doing on a daily basis? Have they completed it with her? What's going on? And with that, I'll end, Your Honor.
I appreciate that. Ms. Chrome, you heard that when they were first indicating that they prefer the Friday evening to Sunday evening, but they'd agree to Thursday evening to Sunday evening, as long as there really will be cooperation and compliance with right of first refusal, whereby dad has to understand if he's working and not available, his girlfriend may be a very appropriate caregiver. I don't know. She may have been read up on Down syndrome or whatever. Who knows? But even if all that were true, he would, by necessity, if we adopt this schedule, have to reach out to mom and give mom first dibs on getting Aslan back instead of Aslan being watched out for, but not whether it's dad's girlfriend or some other third party. So otherwise, we have to look at some different schedule if a right of first refusal isn't going to work. And I'm not sure these parties are at the cooperation level you would need for that, but if they want to give it the old college try and agree to it, that's okay. So what do you think?
The problem that I have is that mom, for her wanting to journal, it just seems weird to me because she hasn't done that so far while she's been taking the child to therapy. To want this 6-hour turnaround is something that is new. All of her other withholding, which she's been withholding for months, all of her messages are related to who is he dating and what's going on in his life. So in this child, my client does not sign, and mom will admit he has a great relationship with this child. He's been able to care for this child. It doesn't mean that, just because he's a working parent that he shouldn't have quality time with her. The grandmother has lived in the house. Both parties have utilized his mother as a third-party caregiver as well, which I've explained to counsel. The Thursday through Sunday schedule would work best for him because he's off on the weekends. If this court is inclined that he would have to give up a day, if he doesn't agree to temporarily a right of first refusal, then he'll do temporary right of first refusal. But I think based upon the extremely high conflict nature of this case, where mom has blasted dad, made allegations, and then she withdraws them. She says he's violent, then she withdraws that. She says he's committed acts of sexual violence against other people, then withdraws that. That I'm concerned that if we include a right of first refusal, she's going to honestly stalk him and make new allegations against him. It's just going to increase the issues in this court, and it'll be harder for us to resolve it. I think that he, as a parent, has a fundamental right to parent when this child is in his custody. He's been able to do so successfully until she withheld the child. Mom, again, we're hoping the schedule works because mom is confirmed in her paperwork that she's on her proper medication, and we're hoping there won't be any new suicide attempts because she's had 2. So we're taking this cautiously, but to add more stress of them interacting and him having to contact her every single time that he's not available, my concern, she's going to come back before you and say, see, Judge, I have primary.
I just think that they're made for each other. I think they should try counseling.
Just because a parent works doesn't mean that they're, fail to be a caregiver for their child. And mom's going to get a job.
Well, it
So
would be understood
hopefully
that
she'll get a
it
job
would be
soon.
understood this temporary arrangement, they'd be precluded from arguing that additional timeshare to bolster that on a very temporary basis to use to bolster a permanent custody request. In point of fact, the court, rather than bean counting, would probably give some real brownie points to Dad on that issue. Wouldn't that make sense? If I see that level of cooperation, because these things are hard to monitor or approve, whether someone's going to be gone, always to work in a given day, all of this stuff. If someone goes out of their way to be totally candid and offer the other side, yes, I got called in for another shift, or I got so many errands today that I'll be gone 6 or 7 hours. That so
I agree
you can have
wholeheartedly.
Ashlyn. I think that would inure to his benefit to a significant extent. I think even though, I share your concern about too much interaction and that rights of first refusal are reserved for the most cooperative of cases, which this doesn't classify as. I agree with you 100% on that. Yet by the same token, this would be a golden opportunity, arguably, for him to bolster his ultimate custody case if it looks to the court like every time that he's very honorable, and every time that he's going to be gone 6 or 8 hours, he tells mom and effectuate an exchange. So, because I'm kind of inclined on the right of first refusal to go the Thursday to Sunday if he can commit to that cooperation and decency level and candor level, but more so that if we don't have a right of first refusal, it would be more week 1, the Thursday to Sunday, and week 2, the 3 days, and then week 2, the 2 days, Friday to Sunday, and then we rotate until we return. So whichever option you and your client find more palatable, you could tell me that now.
Yeah. He has missed so much time, Judge, that he will agree to the right of first refusal temporarily, but I would ask that the court make it mutual so that when mom secures employment, they can just post their schedules on Talking Parent. If I can address the 6-hour issue.
This isn't just him agreeing to an order so that he can secure more time. And if you need a breakout session with him, because he has to really commit to the process. I don't want him complying just because it's a court order, because candidly, in pure enforcement for court order purposes is going to be difficult to prove. He has to be on the honor system, and we have to change the way we do business, so to the point where we don't even have to question whether he's complying with a court order, because he's a font of cooperation. And as Ms. Roberts said, everybody keep a journal and everything. So if you feel that
he is, and so
if you feel your client is really going to play fair with mom and inform her, even if he thinks it's going to invite some unpleasant dialogue about historical material, he needs to commit to it. And it could be
He did. When I put you on mute, Judge, he said he's committed. What my concern is that if she gets a job in the interim, I would ask that she commit as well. That was from me.
I don't necessarily think, with what we know of the dynamics here, including medical, psychological, historical, I don't necessarily think we have to worry about. It's long-term, that's a necessity. It may even be a court order, arguably, but I don't think we have to worry about any full-time employment necessarily occurring in the next 2 or 3 months, but until we return.
I
But
don't
Ms.
know.
Roberts could obviously speak to that more clearly.
Your Honor, if mom gets a job, Your Honor, I don't think that she's disagreeing that there would be a first right of refusal, because I think under joint legal custody, they both have a right to know who would be caring for the child. My client's position is that grandma has only been able to do it like a couple hours at a time, because she's not physically able to do it more than that. So Kimberly, can you just unmute yourself and confirm that if you get a job, first right of refusal would be given to Dad as well?
Yes, I confirm that.
Perfect, Your Honor. So that's the confirmation. And then the only thing we need from you, Your Honor, is the response time on our Family Wizard.
Right, and if I could just respond to that, I just worry about there being additional issues of contempt. If they could both post on Family Wizard, I suggested that he post on Wednesdays, just kind of update of what's going on during the week or whatever, whichever day of the week. So he could do it on Sundays, and that she would do it on Wednesdays. And then if there's an emergency, they send a text saying, I need an immediate response to Talking parents, can you please look today, that they would text that. But to recommend every 6 hours when he works full time, we're going to be back here on, contempt issues. And I don't think there'll be that many emergencies. She takes the same medication.
You don't really think that this court would hold your client in contempt on that type of issue? Maybe if he refuses to return a child for a long period of time, maybe. But something like that, this court's not punitive or draconian like that.
Right, so why have it in an order? You know what I mean? If there's an emergency, they should start communicating regarding emergencies. I think they don't need to pass a journal, they should use the app as a journal instead of passing a book back and forth.
Your Honor, may I address that? I'm sorry, Shaka.
That's a good
go
point.
ahead.
That's a good point, though. Yes.
So, Your Honor, and I have no problem if Dad were actually responding on our Family Wizard to Mom's questions that are joint legal custody in nature, then I would have no issue with not having response time. The typical response time to our Family Wizard from almost every judge that I've ever been in front of is 24 hours. But this is a special needs child. So when Mom asks a question about their special needs child and doesn't get a response for more than a week, that's not acceptable to me. That, in fact, raises questions about Dad's fitness.
True, can we commit that the 6 or 8 period, not necessarily emergency matters, but matters of some seriousness or medical or care of child import, that it would have to be something non-frivolous or not minor. If it's something of some real arguable significance, then yeah, then everyone has their phone. Dad has his phone with him. He arguably gets breaks or lunches at work. So if it's in something important.
That was in 2023. We're still in 2021.
And no, I can't define important today. That's totally subjective. But something important, he can be expected to respond in 8 hours. If it looks like he's being bedeviled with minutia, then as you both indicate, that's something else altogether. One person's minutia may be another person's quote unquote serious issues of import, so who knows,
I think that's acceptable, Your Honor. What I will do with Ms. Chrome today, actually, is the questions that have gone unanswered, because my client says that there are 8 outstanding questions on talking parents that have been weeks old or days old. I will communicate those with Ms. Chrome, and if she can respond to me by Friday with the answers, then I think that will resolve the outstanding issue, and then going forward, we can just do the 8 hours response time on the issues regarding the child.
I'm fine with responding.
Based on how things are progressing, when you all four get around the table, and arguably with a neutral, if not all 4 of you by yourself, I don't think you're going to have any real trouble settling the case except for one big issue.
Boy, was he
wrong. If Mom still intends to relocate to Florida at this time, then obviously we probably have a trial issue, because I don't want to jinx any settlements, but I doubt we're going to see a stipulation by either parent that someone can move out of the state with their daughter, but I could be wrong about that. But
I still think we want the senior.
I guess there's an undercurrent to my remark. Can they reach a settlement where the Florida relocation is not necessarily denied, but it's deferred and could conceivably be
absolutely, Your Honor. Yes, that's why we suggested the senior judge settlement conference.
It's not like there's a really.
If she would just stop talking over the judge, that would be great.
Compelling, unique job offer there, or anything else, or any huge financial. Maybe there is some financial benefit, but time is not of the essence on that necessarily. So that's why I'm suggesting maybe. Since I don't think you'll come to I know you're not going to come to a resolution if we expect someone to agree to the relocation, but you also may have trouble coming to a resolution if it's denied outright. So if you can agree that it's deferred, but the court has jurisdiction to deal with it over the next year or two, if Mom presents a pretty solid case, then that kind of qualifying language that gives everyone a little flexibility and a lot of wiggle room might kind of help. So please keep that in mind.
Yes, Your Honor, she's willing to discuss removing the.
CJ, I absolutely love you so much.
request to relocate if we can settle the case.
And I think if you remove or at least defer that request with the understanding it can crop up in the future if there's enough substance to it, I'm confident you're going to get the case settled. This is the way it sounds.
And I believe it can be settled, Your Honor, with the assistance of a senior judge or a sitting judge. So
just sit back, relax, and go with it. It'll be fine.
I can prepare the order and send it over to Ms. Crone. I will get her the letter today regarding the outstanding issues on talking parents. And then I think that we can work toward a settlement conference as based upon the terms that the court has given us today.
Sure, and for today's purposes, we accept a joint legal custody, specific definition, parties have stipulated, that'll be in the order. If they need a behavior order, one can be provided. The attorneys will meet and confer on child support and the other, if they also want to deal, I think we've resolved the temporary issue pending a settlement conference as to custody, but they can settle ongoing custody or at least custody till trial, or hopefully no trial will not be necessary and they can arrive at an indefinite schedule. I hate to say permanent. Talking parents, 8-hour response time is reasonable with Aslan having Down syndrome, providing that it doesn't have to be an emergency, but it has to be a relatively serious issue of import, and I can't define that now, and there'll be subjective opinions on that, which vary between the parents. Plus, I like the idea of the weekly updates that was suggested, so that should be imposed. The recording the exchanges, I'm not thrilled about it, but I kind of hate getting in the way of stipulations by skilled counsel of this caliber, so be it. The senior or judicial settlement conference is ordered, and we'll see in a minute what the specifics of that is. Of course, paternity is confirmed. I expect that I don't really wish to, unless the attorneys insist, I don't wish to postpone the social media removal posts as to adverse material, because it implies that some sort of stipulation would be reasonable that does not embrace a complete aggressive requirement to remove immediately and to control third parties and direct them to remove immediately. And in fact, I am going to not take that off the attorney's plate, so they have one less thing to worry about, because the only stipulation the court would accept on that is all such material should
O.J.
be
Simpson.
removed within 24 hours. If at the conclusion of this hearing someone tells me they need a little more than 24 hours to remove it, they will. And then step 2, they are to direct all third parties connected or associated with them who are giving them moral support, quote unquote moral support, by helping them bash the other side on social media. If that dynamic exists to any extent, you instruct those friends, those relatives, significant others, whatever, to remove that material. That you appreciate you appreciate their moral support and them lending a shoulder, but unfortunately, this situation, although well-intended, is only going to really damage my custodial chances. That's what you're to tell them. Then if they won't remove it, I expect a sworn affidavit under penalty of perjury with specific dates, times. I told Aunt Myrtle to remove this post on such and such date. I even told her that it's going to harm, not me, but will harm my custody case if she doesn't remove it. And Aunt Myrtle said, pound sand, F you, no one can tell me what to do. And the other side deserves this, I'm just telling them the truth or whatever. And that I implored Aunt Myrtle to remove it. That's the degree of specificity I would need before I tell a party, okay, you're right, this third party's out of control, and even though they're associated with you, neither you or anyone could control this person. So I really have a no-nonsense policy about that. Because even though we have a Down syndrome child who obviously cannot read or comprehend the material, she'll be of an age in the future where someone, if this problem lingers and these matters linger and escalate, if she's 8, 10, or 12, or even younger, and people start telling them, oh, I saw this about your mom and dad, it's really a horrific situation. And the studies on these are just starting, and it's alarming the long-term effect. At this time, we don't need a technical, physical, custodial designation, but Dad will have Thursdays 5:30 to Sundays 5:30. The right of first refusal, the court's taking a leap of faith, because I'm impressed and delighted with the progress. The attorneys are gutting a lot of the case right here with stipulations. It only tends to...
Oh, you poor soul. You poor soul. Being impressed with the progress they're making. Oh boy.
Work in the top 5% of cooperative parents. These parties are not remotely close to the top 5% at this time and still remain in moderate to even high conflict, depending how you look at it. But under the circumstances, I believe Dad, when he instructed Ms. Crum to agree to this, it appears to the court that he understands and is committed to make this work, and he will be on the honor system. And even if his significant other were to tell him, hey, I can handle this. What's the problem? Don't you trust me? He says, of course I trust you and know you love and care for Eslyn, but this is what I'm required to do to get this additional time for now, and I just have to. I'm on the honor system now. We haven't exactly agreed. I don't think whether that's 6 or 8 hours or what hours would apply to that. So we'll see where we are. If mom has any special instructions as to Eslyn's Down syndrome situation that she thinks Dad is not as nearly as clear on as Mom, and it would appear that may possibly be the case for no fault of Dad, but just by the fact that Mom has been sort of the expert and the caregiver primarily all along and the point person as to Down syndrome issues, although I'm not, of course, at all minimizing Dad's incredible love and contributions in this arena. But if there is anything like that she's a little uncomfortable because she's not sure Dad knows about either education, tutorial matters, diet, or intervals of medication and MG's amounts of medications, she'll put that all on Talking Parents and make sure that Dad has the list, or you exchange it at the settlement conference. Mom, of course, has to, and it doesn't sound like it's an issue, so it's probably an unnecessary order, but Mom, of course, has to remain on all her prescribed medication and follow all medical/therapeutic instructions. I haven't heard that she's not, but that's just a standard order the court issues if a parent experiences certain medical and or other challenges. So at this point, if there's any medications to address either depression or anxiety or anything else, and I have reason to believe there are, and they may be multiple, as like 3 or 4, as long as she remains on them and follows doctor's orders, it's a non-issue. And of course, I haven't heard anything medical applies to Dad, but if so, then of course it's a mutual order. Now, and as far as the exchange at the Henderson Police Department, if we're not going inside the police station but dealing with these issues of, well, this person can approach, this person will remain in this car, and this other person will be 8.7 feet away and at a 68.2 degree angle and all this, and the lunar eclipse has to be in this position. The problem with all of those sorts of behavioral minutia conditions, although certainly well-intended, it might have the opposite effect. I think we have to streamline and simplify. Instead of these rules, who approaches the car, who remains in how many feet away, park the cars, walk into the Henderson Police Station, inside at the sergeant's gate. Either that, or you exchange at the family court gate here at the assigned times, or some other, or if you want to remove that sort of supervisory / law enforcement type of oversight, and they feel comfortable at a food court somewhere, or even dropping off at each other's homes. I wouldn't recommend that now, but we can loosen if you need to keep it with a law enforcement type element, it'll either be the family court gate or inside the Henderson Police Department. I don't want them exchanging each other's houses unless there's a stipulation to that, which I'm not hearing. If they feel comfortable at a food court or a hamburger stand or someplace that's very busy, and they stipulate, I'm not too concerned. I think we'll be all right, but I'll leave it to the parties. So before we get our information about the settlement judges, let's see. Now,
may I ask a couple things,
as far as that
when
last
you're
issue, where do they wish to exchange?
So, Your Honor, my client's position is that the Henderson Police Department is convenient, and so it works for both of them. Unfortunately, the Henderson Police Department is not open when they do their exchanges because of COVID-19, but it is in the parking lot and there's recordings. So what I would suggest is, given that we can record exchanges, my hope is that with the specific orders from this court, that we can start reducing the conflict for these parties, and that Ms. Chrome and I, if there is an issue in the future, could come up with a more defined method if there is an alleged problem with the exchanges. So my thought is, let's let them do this exchange for like 30 to 60 days, and if there's an issue, Ms. Chrome and I can communicate regarding that and hopefully resolve it. I mean, we resolved the vast majority of the issues today with just our communication this morning while we were waiting for the court, and I'm not complaining about that because it did allow us all I just want to be clear, because it did allow us the time to go over all of those, and I feel that I have enough client control and Ms. Chrome have enough client control that if we can't resolve this, that we could resolve this issue in the event that a problem crops up in the next 4 weeks.
You know,
So as to the specific method, I think we should leave that undefined.
Yeah, and I think this case should settle because it does appear to the court that what's being discussed may not really be what's at issue. I don't think either side honestly believes their daughter is not receiving fine and full care, sufficient care with the other parent. I think that it's a very unfortunate situation where mom, who is not necessarily a younger parent and may even have, I believe, a young adult male child at this time when she had Ashlyn, and Ashlyn has Down syndrome. They needed this intact relationship to make this work, and it appears there's some real devastation. Not only did Dad leave the relationship, but hooked up with someone else almost immediately. And I'm not bringing that up to make the parties feel bad. In fact, quite the opposite. I think if we recognize what's going on here, that there's some real hurt, and that's what's going on, some real hurt, and mom has apparently a right to be hurt or even devastated, but still she is to recognize, and they both do, that issue is separate and apart. The court really can't do anything about that. I just have to make sure their daughter is adequately cared for by both, and it seems is receiving sterling care with mom, and I don't have any real doubt at this time that Dad's also going to rise to the same level or comparably so. So the parties have to understand this, the baggage and psychological dynamics between the two of them, which I'm not minimizing, are devastating, I think, for mom. But we have to do our best not to let that bleed over into these issues of arranging a fair schedule with Ashlyn and recognizing the great benefits that both parents bring to the table. And I dare say substantial progress with the wonderful assistance of the attorneys is occurring in that direction. So let's move on with that approach that we've heard today and not get backtracked to the kind of tone we heard in the paperwork, which kind of had the court thinking more in terms of the devastation and hurt and tumult in the...
If anybody had just walked in, please remember to watch the first 3 minutes because it's epic. Oh man, it's really good.
The relationship and how mom suffered by that breakup, and understandably so, and Dad maybe candidly jumping the gun a little bit, which is just going to add fuel to the fire, getting into a new relationship right away. So all I'm saying is I understand how the parties feel about those issues, but the more, and then I double read the briefs, and it still came across that way, that I don't really have to be concerned that this little girl is going to receive the full love and support of both parents, and we kind of have to compartmentalize those other issues as difficult as they are and not let them bleed over. But with that all said, again, if mom does have some legitimate concerns as to is Dad really on top of all these issues to the extent he should be, that's why I instructed her to prepare a care sheet that Ms. Roberts will make certain can be transmitted at the settlement conference or earlier. Now, that all said, what did we find out about a settlement conference?
The law clerk is going to work with Controller's Department.
Okay, and I think I better pose that to Ms. Roberts. It looks like with the senior judge formal program and the formal judicial settlement program, which it consists of currently sitting, family court judges, of course, well, the senior program is the retired judges. It looks like we don't have close availability, and to these judges who assist with overflow, it looks like Judge Ochoa would be the most obvious candidate for a very close-in referral. And with the understanding, of course, that this is not arbitration, but it's just mediation, having a conversation with the judge to assist with settlement. Is there any objection? Do you want us to try and secure Judge?
No, Your Honor, not at all.
Okay.
No, not at all. Judge Ochoa, I have no objection with Judge Ochoa unless Ms. Crum does. I'm fine with Judge Ochoa doing it.
Right, and I'm just erring on the side of caution because I know that material the court referred to is way back in 2013 or 14, and but I just wanted to make sure, and you already answered to say there's a possibility of a case-by-case recusal, but there's no blanket recusal. So we'll coordinate that. Should they contact his department directly or coordinate it through ours?
Probably contact.
Okay.
Your Honor, can I make one more request?
Yes?
Can I make one more request? So previously, on one of the exchanges, they were operating where mom was taking the minor child while dad was at work. And so he would meet her before he went to work and then pick her up, that night. So it's anticipated she's going to take every Friday. So in exchange for doing that the last time, he had Tuesday to Wednesday at 10 a.m. So, and I think mom liked that schedule. I'm not sure, so I'm just asking if we could have a schedule where he would also have, Tuesday night to Wednesday morning, and they exchange, and then, because we know every Friday she's going to have the child until he gets off of work.
There's no prejudice to dad for mom exercising the time while he's at work. So at this point, the schedule is joint physical custody. We can see how this schedule works, and if it doesn't work, then we can come up with some other plan and try to look at that. I don't have a problem with that, but I think we're rehashing everything we've already gone through if we then ask to modify the schedule further.
Right.
He on that Thursday through Sunday, and she
It
agreed.
can be thrashed out at the Ochoa conference. Now, should we have a 90-day return as to status/results of settlement conference, a 120-day return? Or are you hoping to get before Ochoa just within the next month or next few weeks, which I think he'll be able to accomplish?
My concern, Your Honor, is Judge Ochoa, we've asked for an OST, and he's indicated that he doesn't have any time. So I'm thinking it's at least 120 days, but if the court has an indication that it's going to be...
We'll make it 120, but, and what you identified could possibly be a slightly different dynamic. A judge may not necessarily have a lot of court time for...
Absolutely, Your Honor.
They still may be able to arrange a settlement conference on their so-called admin day, but I hear what you're saying. So we'll make it 20 just to be safe, but hope the conference, you'll try and arrange that immediately and try and meet with them within the next month. Okay, our 120-day
That's fine, Your Honor.
for status/results of settlement conference.
Can we say, just because I'm covering Mr. Stavel's cases, I can't guarantee I can do it within the next month, Your Honor. I have a lot of trials, so I could agree that we could try to do it within the next 60 days.
You don't have to, it's just that we don't want it 90 or 100 or 110.
Oh, that's fine, Your Honor.
It's more of an aspirational remark by the court. If it has to be 2 months,
That's fine.
whatever. Okay, so the date, October
21st at 11.
October 21st at 11, please. October 21st, 21 at 11. Status.
Yes, Your Honor.
Status/results of judicial settlement conference. All right. Great work.
I'll prepare the order and send it over to Ms. Crum, Your Honor.
Great work. Thanks so much. Schedule starts.
Thank you, Your Honor.
immediately. Thanks.
Yes, Your Honor.
All right, thank
Like
you.
today. Ms. Hurd,
All right. We made it through the first parts of this crazy case. Tomorrow I'll have it in better order of where we go from here. The judge is very optimistic about how this is going in 2022. Now we know why he's like that in 2023. Because he went through all of this. And then she got rid of her lawyers. And then he knew it was going to be bad, bad, bad. I do have this set up. So we are automatically going to jump right into the Simpson stream. But if you don't stay for that, thank you very much for coming out. I really, really, really appreciate it. Yeah, there'll be a quiz, all right. Oh my gosh. Kelly found that. Kelly gave me that nugget of gorgeousness. Bye, guys. I'll see you in a few minutes. All right?
right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue, in her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a way there's no alarm. Feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's life.